right, good afternoon. I'm Angela Onwachi-Willig, Dean of Boston University's School of Law, and I want to welcome you to our annual Max M. Shapiro Lecture. Max Shapiro graduated from BU Law in 1933 and embarked on a successful 60-year career as a trial lawyer. In addition to his remarkable dedication to each and every case he tried, Max embraced the role of mentor, inspiring younger attorneys through the strength of his character. Shapiro Lecture serves as a fitting tribute to the memory of a lawyer devoted to advancing the cause of legal ethics and trial advocacy. Coincidentally, today would have been Mr. Shapiro's 110th birthday, so it's particularly appropriate to celebrate his memory on this special occasion. We're grateful to Max's son, Andrew, his daughter, Sue Ellen, and her husband, Larry, for funding this endowed lecture to honor his legacy. Today's speaker is William H. Groner, a graduate from our class of 1980, who has previously served as an adjunct faculty member. Mr. Groner is founder and CEO of Settlement Systems Arbitration and Mediation, otherwise known as SSAM, Alternative Dispute Resolution. Prior to establishing this firm, Mr. Groner served for 35 years as a litigation attorney, representing clients in insurance and surety companies in construction law cases. During those years, Mr. Groner participated in countless mediations and hundreds of negotiations involving settlements in excess of $1 billion. Mr. Groner is perhaps best known for co-managing 9/11 mass tort, representing more than 10,000 first responders, construction workers, volunteers, and others who were exposed to toxins and contaminants when responding to and cleaning up Ground Zero in the aftermath of 9/11. And in this work, he served as a principal negotiator and architect of the resulting settlement in excess of $800 million. In 2019, Mr. Groner released a book along with his co-author titled 9/12, The Epic Battle of the Ground Zero Responders, which details the decade-long legal fight to acknowledge and compensate these victims. Kenneth Feinberg, the attorney appointed as special master of the federal government's September 11th Victims Compensation Fund, as well as the fund established by the Commonwealth of Massachusetts for victims of the 2013 Boston Marathon bombings, proclaimed that Mr. Groner's book is, quote, required reading for all Americans interested in the legacy of 9/11, end quote. Mr. Feinberg continued, quote, many citizens believe the tragedy of 9/11 ended with the attacks themselves, but this book tells the full story of the courage and determination of first responders and their allies over the next decade, end quote. And might I say, it also tells the story of the determination and extreme skill, excellent skill of Mr. Bill Groner, class of 1980 at BU Law. I want to thank you all for joining us for the 2021 Max M. Shapiro Lecture. I want to remind everyone that you can ask questions and the Q&A part down at the bottom of the Zoom box. And now it's my sincere pleasure to introduce Bill Groner. Thank you, Mr. Groner.
Thank you, Dean. And I'm thrilled and honored to be giving this talk today to the BU Law community and our friends and family. The talk will be far-ranging and will certainly deal with the issues that I incurred during my representation of the responders, but will morph into my reflections upon lawyers, their responsibilities in today's society. So let me start off by, before I go back years ago, I'm going to start off at 2021. Who would have guessed it? Who would have ever predicted that we would be living in perhaps the most consequential time in generations? Our country, over its initial 250 years, faced and traversed fundamental issues inherent in the development of a free society. Independence from an oppressive sovereign, slavery, basic civil rights, equality of women, international threats to our safety and way of life posed by common enemies, and so much more. After going through these developmental growing pains and the consequent evolution of our community of people. Many have felt that our concepts of democracy and society were working so well that we weren't just a successful nation, but a beacon of hope for the rest of the world. Many of us lived every day with this grand feeling of American greatness and leadership. And while basking in our perceived success as a nation, lurking below the surface were tensions that belied our achievements and would soon rise to the surface. Tensions such as racial inequality that have had centuries of foothold. And simmering was the growing divide between many groups of people. Those who believed in less government and those who believed that government was the answer to inequality. Divisions between the haves and the have-nots, the educated, the uneducated, the rural and the urban, those born with privilege and those who simply didn't have the same chances to achieve the American dream based simply upon the circumstances they were born into. And then along came COVID, added gasoline to these growing fires. The merger and cataclysm of these simultaneous forces exploded so fast that in an instant, discussions of formerly unspeakable things became commonplace. Civil war, states' succession, and incredibly, autocracy. But to me, the fundamental question that has arisen is not, does democracy work, but does our society work? Can 330 million people actually live together in enough harmony? Surely these are profound questions with no short or easy answers. But from the throes of despair arise the greatest opportunities for growth. In my lifetime, I've never seen a greater chance for our society to grow and to evolve. Americans of every age, gender, race, and religion are aware of our issues, are thinking about them, and are talking about them. Ironically, our common foe of divisiveness has joined us together. But much more than talking is needed. We need positive action by every single member of our society that is capable of doing so. Action focused not on me, not on ourself, but upon we, our society. Today, I want to start a conversation about some of the things that we as lawyers and lawyers to be can do for our society in our time of need. Let's go back a step. Structurally, society provides us with the foundations to be safe and to prosper. We're provided with laws and enforcement of them, infrastructure, education, health, protection from common enemies. But community isn't a one-way street. As in most things in life, we can't simply take and not give back. Successful society isn't about me, it's about we. Along these conceptual lines, I recently had the privilege to give a TEDx talk entitled 9/12 From Me to We. It was based upon my representation of the Ground Zero responders. In the TEDx talk, I discuss a beautiful story about one detective who represented thousands of others who placed we above me. I'm going to give a little synopsis of that story in that TEDx talk right now. After 9/11, tens of thousands of responders came to the Ground Zero site and for the next 9 months worked on a rescue and recovery mission and then a massive cleanup. Now on 9/11, everything in the trade towers, except for the structural steel, turned into dust. The walls, the floors, the ceilings, the light fixtures, computers, mechanical equipment, all containing hundreds of contaminants, all turning into dust. Toxic dust that had the same pH as ammonia. Dust inhaled deeply into the lungs by these heroic Ground Zero responders, as if they were not given proper personal protective equipment. And as a result, thousands become ill to their exposures. Incredibly, despite their heroism and injuries, they were denied compensation. Over the ensuing decade, I and my partners had the honor of representing 10,000 of them in their fight for validation and their fight for compensation. Finally, years into the litigation, we achieved a prospective settlement. Now, unfortunately, at that point in time, it was nearly impossible to prove that the dust caused cancer. Essentially, toxic exposure can cause cancer, but our oncological experts said it would take typically 10 or more years to cause blood cancers and 20 or more years to cause solid tumor cancers. Yet many of our clients suffered cancer just 3 to 5 years after their exposure, well sooner than the expected latency period. And as told to me by the director of NIOSH, the National Institute of Occupational Safety and Health, when we talked about this cancer causation question, he said, this is Dr. John Howard, Bill, it's beyond science to show that your client's cancers are related to the dust. Well, we as lawyers didn't remotely accept this, but unfortunately, it factored into the settlement negotiations. And those clients who had cancer were going to receive relatively small settlements. One of these responders was Detective Candace Baker, who suffered many injuries, including breast cancer, from her heroic work, and that resulted in a double mastectomy. At a settlement fairness hearing called by the court, Detective Baker volunteered to speak. In fact, she demanded to speak. The judge, once she approached the pulpit, asked her whether he should approve the settlement. Hundreds in the courtroom and the overflow courtroom waited with bated breath for her response. Now, after everything she'd been through, here was her chance to talk about her personal pain and losses. Yet she didn't complain about not being told the truth about the dangers of the dust or not being given proper equipment. She didn't denounce the defendants for saying her cancer wasn't related or criticize the fact that it took 10 years to get to this place in the settlement, or that her compensation was so little. Rather, with incredible honor and dignity, she told the judge that if faced with the same situation, she would do it all over again. Detective Baker chose we over me. Now, her selflessness and focus on society is but one example of what individuals can do. But I'm not suggesting that we all have to become first responders or join the military or go into service. I am suggesting that thinking about and acting towards others, towards community, towards society are not only a positive action, but essential if we are to become a healthier nation. Clearly, how much one can give and care about others depends upon their circumstances. A family struggling to put food on their table can't possibly be expected by us to put the same time and energy towards building a healthier community as those whose circumstances aren't as dire. Certainly, those folks of lesser circumstances or privilege need first take care of themselves and their families. But for those of us that can, we should and we must. And today I turn this conversation to the legal community. First, I want to discuss lawyers' relationships with our clients. And to do this, I go back to the ground zero story. In that litigation, our task in seeking compensation for 10,000 responders was Herculean, not just because of the number of clients, but because of the sheer complexity of proving the quantity of toxins that each and every client inhaled. Worse, we had to prove that the dust caused injuries that medical science had never seen before. This was made even more difficult by the fact that the city and the 150 defendants that we were suing were backed by a $1 billion insurance fund supplied by FEMA. And incredibly, this war chest was used, not for paying claims, but instead as a defense fund to try and dismiss the responders' claims based upon an archaic immunity argument. In fact, over $250 million was spent for defense costs to do everything legally possible to throw our cases out of court. The resulting fight to the death litigation has been labeled by legal scholars as the most complex mass tort in history. Our difficulties in winning were overwhelming. Virtually unlimited funds were being used by smart and accomplished lawyers, while plaintiffs' counsel had to borrow tens of millions of dollars to pay the expenses as we worked on a contingency fee arrangement. There were a host of causation issues that would make a tort scholar's head spin. A mass tort involving 10,000 individual cases would have to be tried separately as class status was denied. So that if each case took 1 month to try, it would take us 1,000 years to try these cases. All this resulting in a near 10-year, 24/7 legal battle that felt never ending. Finally, in 2010, almost 10 years after 9/11, it was 10 years after 9/11, we achieved a proposed settlement which required 95% of our clients to agree, which was 9,500 out of 10,000 responders. Having been a chief plaintiff's architect of the complex settlement, I was tasked by my partners to go to offices, town halls, and hotels to educate our clients about the proposed settlement. Now, the concept of success is elusive and subjective, but by almost every measure, this proposed settlement was a success. Despite the nearly insurmountable difficulties we faced, the proposed settlement had nearly $900 million to be distributed based upon objectively proven injuries. And my clients would finally get the validation and closure they desperately needed. To most town halls, I was greeted with great relief and appreciation. But at some meetings, I was greeted with such hostility that I actually feared for my safety. I was faced with outrage and unrelenting questions spiced with utter contempt for the lawyers. The anger was evident from the questions often screamed at me. Why did this take so long? Why aren't we getting more money? Why isn't cancer getting a higher payout? Do you even care about us or just care about the money that you're going to make? Why don't you talk to us throughout these years and give us updates? You see, to these clients, this proposed settlement clearly was not a success, and the lawyers, the law, the court, and society had let them down. We created this successful settlement proposal, but lost some of my clients' faith along the way. A success paradox. One could say their unhappiness was subjective, based upon less than all the facts, but perception is reality, and their thoughts and feelings were entitled to unmitigated respect. The fact that this group may have only represented 5% of my clients did not minimize or negate the fact of this enormous unhappiness. And I often wondered what went so horribly wrong with this group. How did my partners and I fail these heroes? These questions plagued me. And upon reflection, part of the answer is clear. In a word, lack of trust. We fail to deliver the most critical thing that a lawyer can create in an attorney-client relationship. Trust. Trust that we had their interests at heart. Trust that we fought for them as they had expected and needed. By having 10,000 clients, we never created a relationship of trust with our clients. Now, you can say it was impossible, but that's not remotely the point. Consider, when a client comes to a lawyer, they are in need, and therefore they are vulnerable. The attorney-client relationship and duty of confidentiality is designed to make that client have the greatest comfort that not only everything they say is confidential, but that their lawyer, who is a critical player in our system of justice, will do everything in their power to protect their interests. This requisite trust in lawyers promotes trust in our legal system, and trust in our system of laws is foundational for successful society. During the case, I naively thought that because I was working so hard on behalf of my clients, that involving them in the process wasn't critical. Yes, we interacted with them throughout, but in hindsight, every significant event in this case should have been communicated to my clients. Every communication should have been empathetic of the misery that they were experiencing. We should have reached out to them even when there wasn't a significant development, just to let them know we were fighting for them and thinking about them and caring about them. We should have asked them, what else can we do? And allowed them to be involved in the fight of their lives. These are amazing lessons that I want to share with you, because looking forward to all of us who represent clients, the creation of trust is not a particularly hard task. It simply requires that we change the focus from us to them, to see their issues as our issues, to see our communications to them not as an obligation, but as an honor and a privilege. To understand it's not just about you or we as a lawyer, it's about them as a client. Yet, how lawyers can establish a healthier society goes far beyond our relationships with our clients. Our legal and political systems are incredibly complex. The interplay of the different branches of government, the checks and balances, the laws that ensure the integrity of our political and election systems. Each of these must be understood to promote confidence in our citizens. And we lawyers, by virtue of our education experience, we're uniquely qualified to understand and communicate to a public that often doesn't trust our systems, with devastating consequences. Since perception is really reality, how the public perceives our laws and government is critical. There's no better way to discern the public's perception than to listen to the discussions. In the past year, I've heard many questions from friends about the presidential election. I've been asked repeatedly, will the Supreme Court decide the election cases in favor of the sitting president because he appointed several justices? This is a stunning question. Just think about it. This isn't a question about whether a justice who's politically like-minded to the president, they're both on the left, they're both on the right, may rule in line with that political narrative. No, this is a question about whether the highest judicial office holders of our land, those whom the integrity of our system of justice depends, will ignore our laws, throw away their lifetime of honor and integrity, and because of a thank you or a supposed allegiance to the person who nominated them, rule contrary to the law. Now, certainly it's human to have some irrational fears, but these friends weren't just waxing philosophically about what ifs. They were really concerned that this was going to happen. Another question I often heard was, since the president is the commander-in-chief, will military leaders support his wishes, even if they're illegal or against the Constitution? My friends were concerned about a coup. Another constant inquiry, can and will Congress override the will of the state's voters? These questions were enormously disturbing to me, but not because of the questions themselves. I myself was concerned or confused about some of these issues, such as at what point can military commanders ignore the directive of the president, their superior? Or how do we actually certify a presidential election? But at least I had the education, the privilege, the access to do the research or talk to constitutional scholar friends about these concerns. Non-lawyers and the public are not so fortunate. What really horrified me is that these questions showed a complete lack of faith and trust in our system of laws. How can anyone walk around feeling safe and secure about our country without this basic trust? On the last question about the power of Congress to override an election, it was so prevalent and caused so much anxiety. I felt compelled as the representative lawyer in the family and friends group to thoroughly research the issue. And the complexity of what I learned made my head spin. The interplay between the Constitution, the 12th Amendment, the Electoral Count Act, the Joint Session of Congress concurrent resolutions, 3 U.S.C. 15, created a web so complex that I often had to go back and reread portions just to maintain my understanding. But what I learned ratified what I intuitively expected, that our tangled complex of laws and rules made it virtually impossible for any Congress to ever override the will of the state's voters. And I felt an honor and a privilege to share the results of my research and conclusions with my family and friends, who are understandably ignorant about these arcane and complicated rules, and were rightly concerned about the fall or prospective fall of our sacrosanct presidential election system. And my research and explanation made big differences to many whose faith in our election system was greatly shaken. Now, I use the word ignorance, and I hesitate to use that word because of its perceived pejorative nature. But ignorance, and I looked this up in the dictionary, isn't a judgment. Rather it's a state of being. As per the dictionary, it says that ignorance is the state of lack of knowledge, information, or learning. Ignorance is society's vulnerability. It's our Achilles heel. It's not a left versus right thing, an urban versus suburban thing, a red versus blue thing. It's ever present within all of us, but it disconnects us and it prevents our growth as a society. For those listening who doubt that you are ignorant, consider the last time someone said something that you disagree with. Did you ask them why they feel that way? Because if you didn't, then you and I are ignorant of how they are feeling and why. And this ignorance and lack of empathy to those we disagree with is as much an obstacle to a healthy society as ignorance of objective facts. While this itself can be a broad-ranging conversation, for now I just want to focus on one part of it, what we as lawyers can do in response to our citizens' ignorance of our systems of law and government. As elucidated in the situation where I went and did research about the electoral process, and I shared it with my circle of family and friends, we as lawyers, and by virtue of our unique education and experience in the law, can have a huge role in bettering society. We can be a voice of explanation, a voice of education, a voice of reason, and a voice of calm for these issues that arise relating to the sanctity of our very system of governing. However, beware. The successful development of trust in us as lawyers, as the voices of education and reason, it has conditions. Critically, communications designed to restore trust in our laws and systems must be non-partisan. And this should be easy to accomplish. The question of whether or not the Supreme Court will rule in favor of a president who appointed some of its members should have nothing to do with political party and which side presented the issue. Any communication by us as lawyers designed to assist friends, family, or the public to understand our system that has a tinge of partisanship, will die at inception. Similarly, facts and objective truths must carry the day. Society cannot exist, much less prosper, without facts and objective truths. There's an elephant in the room, though. We all have cognitive biases. These biases influence our perception, they influence our recall, and they influence our expression. We're human, we're not computers. So no matter how objective we feel we are, there is often a subjectivity that is already built in. This should not deter us, though. This should inform us. It is absolutely critical that we understand that as lawyers, when we speak to friends, family, clients, or society in general, we are seen as representatives of our legal system. We are seen as someone who has devoted themselves to the principles and regulations of a society. Accordingly, as so-called guardians of the law, we have the greatest responsibility to each other, our profession, and to society in general, to speak publicly based upon objective truths. There's little question in 2021, we are a shaken society. Our nation needs to restore its sense that we can all coexist and even thrive together. To do so requires a trust by our citizens in our most critical infrastructure, our system of laws. But any such growth requires icons of integrity and character. We need spokespersons for the sanctity of facts and of law. Since the inception of our country, lawyers have had a peculiar and special role in our society. That role needs to grow and evolve to help society face our challenges. By seeing and treating our clients as people and being empathetic and responsive to their questions, needs, and concerns, we have the power to give them faith in the law, in lawyers, and our system of justice. By being a force of education, reason, and excellent communication, we can help reestablish objective truths in a nonpartisan way that will promote trust in our system of government and society at large. I hope you join me in a never-ending challenge to consider every day and in every way what we can each do. Because together, we have the power to advance the health and wellness of our nation in need. Thanks. I'll pass this now back to David.
Well, thank you, Bill, for those great remarks. I'm David Weber. I'm the Associate Dean for Intellectual Life here at the Law School. I'm also a professor here. And so first, I just want to invite everybody, if you have questions for Bill, please put them into the Q&A box at the bottom of your screen, and I'll be moderating and reviewing them and asking them. I did want to just start off on my own. First, just, commending you. Anybody who knows about bringing these mass torts cases understands just how complex they are, and frankly, just how many obstacles the law puts in the way of plaintiffs and their attorneys in such cases. So first of all, I just think it's commendable, because in your situation, where I think people who understand these cases know that that your efforts were indeed successful. I think it's commendable that you are still willing to publicly kind of also offer some critique of what you might have done differently. It's really admirable, because I think many people in your situation could just kind of spike the ball and point to the glories of what was accomplished. But it is admirable the way I think you reflected on what happened with some of the lawyer-client relationship there, what might have been done differently. I wanted to just start off by asking you, now that you have litigated, one of the most high-profile mass torts cases of our time, I'm curious to know, what could and should we be doing differently to deal with problems like this? I mean, I teach civil procedure, and I have to teach my students every year about how difficult to impossible it is to certify classes, as what happened in the tobacco cases and in the asbestos cases, et cetera. Are there certain reforms that we could make that would restore credibility, or that would enhance our ability for the legal system to handle these cases, getting people compensation more rapidly, building up credibility and faith in the system itself, and dealing with really tricky and painful problems like what you had to deal with in these 9/11 cases?
Well, I'm addicted to progress. That's what gets me up in the morning. That's what keeps me going. Progress as a person, growth and progress as a society. So I think what we need to do is learn a lot from that. I had a speech recently where I talked about what the city did wrong in terms of at the scene, and why my clients didn't get proper protection. And in the audience were two members of the Emergency Services Unit of the New York City. And this is the agency that's in charge with when there's a catastrophe, they coordinate all the other agencies. And wonderfully, they asked me if I would speak to their agency about, just on a personal protective equipment basis. And in terms of a health and safety perspective, what they could have and should have done, because that's something that we had to study. And it was awesome. I went down there, I spoke in front of, it was like in a bunker. I spoke in front of about 50 people, and we had this awesome, rigorous and vigorous conversation about what I learned about what they could and should have done. So that's one piece of the puzzle. Another piece is, what do we as a society do for these mass catastrophes where we took heroes and we made them to litigants? Do we want to create funds and distribute the compensation? And that's a political issue. It's a sociological issue. It's a legal issue. In hindsight, I think absolutely that there should have been a fund that distributed money to my clients and never get lawyers involved. And now you won't hear a lot of lawyers say that because there's a lot of self-interest out there. But what my clients went through, it wasn't just that they didn't get compensation, is that by being in a diverse litigation perspective, the defense would claim that they were exaggerating, that the injuries weren't related. And it was just insult to injury. You took people that took one for the team. I mean, as tens of thousands ran away from the dust and the site, these people ran towards, and not for ego, but for duty. And to then, put them on the defensive and make them go through what they went through, is a horrible circumstance. So I am a believer of fund, and luckily, as a result of our litigation or corollary to it, the Zadroga Fund has passed, and right now we do have a fund for anybody in Lower Manhattan who has a series of diseases or illness. They can actually apply, and they don't even need a lawyer, and get compensation if they've certain delineated illnesses.
Question from Professor Christopher Robertson. What is your evaluation of the multi-district litigation process as an alternative to class certification?
Well, this was complicated. We had 10,000 cases, and I agreed with the judge in not certifying as a class because every person had different exposure, had different illness, had different latency periods. The number of individual factors made so much lack of commonality that it was impossible to group. But then again, creative minds can, create great solutions. And if I were to advise a court today based on the same thing, I would have grouped these cases. If we were forced into litigation, I would have grouped these cases based upon categories, based upon similarity of illnesses and exposure, and worked through them as a group, whether negotiating, whether have a test trial so both sides can see how juries come out on it, and then use that as the basis and foundation to try and come up with a master resolution.
Question from Professor David Sipe. Is it fair to say that our legal system harnesses the power of individual financial self-interests of plaintiffs and defendants, aided by the zealous advocacy of their lawyers, all in order to achieve social goals for the overall public good? Is this system working as it should? To the extent that each party's financial resources limit the quality of legal representation that each can get, can we keep the system going forward as our country gets more and more unequal in wealth?
Well, let's have a symposium about that question. But we can certainly start the conversation. Certainly, in this case, my clients were not well served by the fact that the government funded $1 billion to the defendants, which they used as a defense fund, and we were scraping for loans to sort of keep up. And as a result, it became a litigation based upon financial resources to some degree. I remember one day the judge pulled me aside and said, "Aren't you guys running out of money? Don't you want to settle?" And, of course, any lawyer that works on a contingency, his own personal interests for good and for bad come into play because his interests are aligned with the client in terms of recovering some compensation. But in this particular case, we were not well served by it, and we were outspent. I can't say we were out-lawyered, and I can say that, right prevailed. But I think this is a huge issue about access to justice and giving people the opportunity to seek, fairness and get access to the system without access to financial resources.
From Professor Gary Lawson, great talk. Lawyers may know more than non-lawyers about some matters. Do they realistically know so much more than non-lawyers about matters of public concern that they are reliable, much less necessary spokespersons on those matters? Is that really a kind of hubris that makes more difficult, not less difficult, the task of fostering communication among people who disagree on fundamental issues of human affairs?
That's a great question. I mean, arrogance has really no place in our society, and lawyers, by virtue of their education, should not feel they have a leg up on things that they simply don't have a leg up on. And when I was writing the speech and talking about or thinking about, what are lawyers' roles, I didn't want to supplant everyone else's role. I mean, we all have a role towards a healthy society. Anybody could have researched and basically understood the Electoral College Act and shared, with their friends and family what they learned. You don't need to be a lawyer to do that. But since this was a community of law students and lawyers, I wanted to direct it towards us. I wanted to say, listen, we have a leg up in a lot of different ways, not in as many ways as you may think. And we have a responsibility to take that leg up and use it for the benefit of society with as much humility as we possibly can muster.
Question from Matthew Medina. Can you speak to how litigation finance has changed recently and what effect, if any, it will have on capital-intensive mass torts cases similar to the 9/11 case? Is there cause for hope or cause for concern here, or both?
Yeah. Well, litigation finance has turned into big business. You've got private equity funds that are involved. The numbers are enormous. The interest rates that can be charged to lawyers can be 20 to 30% annual, simple, and then compounded. So it's each year and then it builds. Unfortunately, lawyers often don't have any other choice, especially those that work on a contingency basis. On the other hand, without this access to these resources, lawyers are really who work on a contingency are really a leg down. So, it's a mixed bag, and there's good and bad. At some point, should there be regulation of it? That's unclear. Now, it's not considered usurious because it's based upon risk. So these lenders generally do not have personal signatures, and they're not the repayment of the loans are not guaranteed by the lawyers personally. They're based upon the success of the litigation. So the world of usury doesn't necessarily apply.
From Professor Nancy Moore, is there an upper limit to the number of clients a lawyer may properly represent in mass tort litigation, i.e. aggregate litigation, as opposed to a class action? You represented 10,000 individual clients, presumably under individual contingent fee arrangements. There are some firms today that purport to simultaneously represent 50,000 individual clients or more in individual arbitrations against the same company. What do you think about that in terms of legal ethics?
Yeah, boy, that's a great question that's plagued me. At one of the meetings with the angry clients, I'll never forget a question, which was, why did you represent so many? As though, you couldn't possibly take care of 10,000 people simultaneously. And, my response then is the same now, which is it's good and bad. I mean, it created the difficulties that I shared in terms of creating that bond and connection with my individual clients. But it gave me the power to control the litigation. It gave me the resources to sort of be heard and direct it in the way that we wanted to direct it. Now, the question of how many clients that lawyers should represent, on an ethical basis is a fascinating question. Our Judge Hellerstein, Alvin Hellerstein in Southern District, was really concerned about this. He was so upset about this that he distrusted us throughout. And when it came time towards communicating with our clients, about the settlement, required that we retain an ethics master, and that ethics person had to approve all of our communications. And I didn't have a problem with that because at the end of the day, thinking about 10,000 people simultaneously and equally is implausible and impossible. What made it worse is we had a lump sum settlement. So we essentially settled for almost $900 million, or a little over $900 million. And we divided that up to our clients based upon a point system that they got based upon their injuries, their severity, and all these other factors and issues that were client specific. Now, if you think about it, if I'm negotiating for breast cancer and I say, I think that my breast cancer clients should be getting 22 points instead of 17 points because I believe more in the causation than you, Mr. Defendant, believes. By arguing that, since it's a single sum game, I'm taking money away from others. So it's fraught with ethical issues and concerns. And I think a judge is well served anytime he has lawyers that are representing large groups of people to have ethics counsel involved to navigate these issues as best they can. It's not perfect, but it can be done. It can be done in the best possible way.
From Professor Kathy Zeiler, for students interested in reforming compensation for injuries in these sorts of mass torts, where do they begin? Who are the deciders and what are the best methods of convincing them?
Yeah, well, reforming injuries, I don't know what that means in terms of reforming the system or reforming, how much people are getting, but I'll attack a few different aspects of it. Right now, it is the Wild West in class actions and mass torts. There's just no question about it. My thoughts and feelings about them in terms of judgments are mixed. What's happening is that you have lawyers are going out there based upon new cases that should be brought, but they're teaming up often with marketing entities, lawyers who specialize in just marketing for clients. And then they're teaming up with people who are funding the litigation. So it's become big business. That does give probably better access by clients to a choice of lawyers. It probably gives a greater opportunity for people to hear and know about these things. And I don't know if it changes the value of the cases, but there are negatives to it. And again, we could have symposiums just about that particular issue. But I didn't see, and I haven't seen reformation necessarily needed in terms of the amounts of awards. There's a sobriety in terms of awards at the mass level that you don't see in individual case level. In other words, when you have an individual case and an individual jury, especially in the federal court system where the appellate courts in the federal system don't like to get involved in overturning or lowering or changing results. When you have individual cases, you can get runaway verdicts, you can get large amounts, you can get verdicts based upon passion and based upon a lot of subjectivity. When you're dealing with mass results, we don't generally often see that. If anything, what I see is awards that are lower than they should be. I remember real quickly when I was about to negotiate with the defendants on GERD, gastroesophageal reflux disease, which was one of the many injuries that my clients had. I went and did research and my partners, and we heard in a mass tort context what a GERD would pay. And I don't know, I'm going to make up a number. I think it was 5 or 10 or 15,000. And I looked at my partners and I said, are you kidding me? This is $100,000 injury. This could be a $500,000 injury. I mean, not generically, but it could be. It's a devastating injury. It affects people's, everything that they eat. It affects their digestive systems. It can affect them 24/7 in terms of pain. But yet in the mass tort world, these things weren't commonly looked at the way we look at them as an individual injury. So I feel good on a mass level that there aren't these runaway results and that the numbers haven't gotten crazy. If anything, I think they need to be, they're understated, the awards.
Question from Andrew Shapiro, BU Law class of 77. What should the bar's position be on Giuliani and others' filing of bogus election lawsuits and to Senator Cruz and Hawley's denial of election results?
Yeah, I wasn't sure where I was going to go in this talk with this issue, and I wanted to stay general and let people sort of consider these issues, but it is clear, And that, to me as a person, as a member of our society and as a member of the bar, that lawyers, when they speak publicly, have an absolute responsibility to society and to the bar to speak truisms. What was most alarming to me about Rudy Giuliani and other lawyers is that what they would say to the public was not what they said in court. And that they knew that the constraints of the legal system and being an officer of the court and responsibilities to the system itself were different than their perceived responsibilities to the public. And I don't agree with that. I don't see how a lawyer says one thing in court and something wider and more outrageous to the public. I think if we care about law as a profession, if we care that it stays the time-honored profession, that lawyers, when they speak to the public, I don't care whether they're grandstanding or not, have to look at the public with the same respect as they look at a judge. And they have to speak as though what they say means something.
Question from Professor Jasmine Gonzalez-Rose. Many celebrated impact class action cases come at great personal costs to lead plaintiffs in terms of stress, mental health tolls, retaliation, unmet expectations. How can attorneys mitigate this? Are there new skills that attorneys should cultivate in working with clients? And is there additional interdisciplinary staff that should team with lawyers like health professionals or social workers?
Oh my gosh, absolutely. That's a fabulous question. We really, listen, for lawyers and for everybody and for all of the society that deals with anxiety and stress, we need to put a lot more time, effort, and attention to those things. The mental health of everyone who's on the firing line. And let's look at, responders right now and everyone in the firing line of COVID. Mental health is incredibly important. And there's lots of things that lawyers can do to minimize their stress, to have a more balanced life. A lot of spiritual things, practical things. And I'm talking about everything from, nutrition, exercise, breathing, meditation, music. Balance is enormous in life. One of the things that, I tried to realize during the 10 years going through this case was the impact it was having to my family. Thank God my wife was amazing because I worked for 24/7 for just about 10 years on this one. And my family was second. They were second to my partners and second to my clients. And my wife was amazing. And I was out of balance. And I could sure have used some guiding forces that would have helped me understand how to compartmentalize things and how not to just be in one speed and to factor in the other parts of my life and understand and respect them as equally important.
What do you say, to someone who's in that role, like a lead plaintiff role, a representative plaintiff role, the disputing, in some areas of law, these folks may be able to get like an additional payment for their service, but in others that's kind of barred. How do you just sort of, lawyer to client manage that kind of representative relationship? I know you spoke admiringly of the detective earlier and what she had to say in that hearing. How in your experience have you managed that? And even just coming back to Professor Gonzalez-Rose's question on that a little bit too, which is, how do you deal with, you mentioned it in terms of the group who were dissatisfied, that 5% group. If you were to have been in dialogue with them all along, what would you have done differently, and how would that reflect maybe what a lawyer who's representing an individual client does in that scenario?
One word comes to my mind about every aspect of your question. That's empathy. I think, what's so interesting about this COVID withdrawal we're all having is, I think, an appreciation by so many of us about that we are social creatures and that we are really deeply connected to each other as people. And, a corollary of that is empathy, to understand, for a lawyer to understand their client, what they're going through, who they are, what they're feeling, what their needs, wants, and desires are, is everything, as though it's themselves. It's, I often talk to lawyers and said the only way that you can really handle a case is you have to, and this is a litigation, is in your own mind, you have to be able to present to a jury this person so well, it's as if it's yourself. You know this person, every aspect about them. I think what happens is once you get into that other person's head and into their world and their life, everything becomes much more natural. What would I have loved to have done? I would have loved, in my case, to have sat down with people throughout and just talk to them, just take 20 at a time, 50 at a time, and just say, talk to me. Let's talk about anything. Talk to me about your fears, your pains, your annoyances. Now, we did this at the end of the case. At the end, when I was trying to educate them about the settlement, we had that. But oh my gosh, their bias at that point was such anger and such contempt that just to bring them even remotely to a neutral point was the work of hours. And I only accomplished that with some of the people. I miss that, as a lawyer. One of the beautiful things about a lawyer is that connection to people, is that, I'm doing something for somebody else. And I didn't have that because I was sort of back scenes until the very end of the case, dealing with, 10,000, issues and each of my clients probably had 1,000 data points, and we had spreadsheets with, tens of millions of data points. I was in that world and I didn't get connected to my clients. I would have gone back and I would have done as much as possible to connect with them.
From Professor Michael Harper and also from an anonymous questioner, we have some. Let's get into the nitty gritty of the case a little bit. So Professor Harper asks, could you explain your client's cause of action and what they had to prove to recover? And we also had a question about who exactly were you litigating against? Who were the defendants here in the 9/11 case that you were litigating?
Okay, so in New York, we have a labor law, which basically says that during construction sites, cleanups, et cetera, everyone on site, the owner, the contractor, the subcontractors, everyone has a responsibility and duty towards a proper and safe workplace. And one of those, and that includes giving proper personal protective equipment. So everyone at that site had a responsibility. So even if my client was a construction worker working for an electrician that was, doing welding and dismembering electrical steel, the plumber contractor had a duty towards them. New York created this amazing labor law where they turned the burden of care to those that had the power, which was the owners, the contractors, and those that had the financial resources. So essentially, all the contractors and the city of New York, and there's 150 contractors, had a duty to provide personal protective equipment and whatever other safety measures were needed on that site. They failed to do that. Unfortunately, and I'll do this real quickly, Rudy Giuliani told the federal agencies, I got this, I'm going to take care of this, I'll bring us back to normalcy. And as a result, the city took over the safety for the site and did a horrible job. My clients were not given the right respirators. They weren't given replacement filters. They weren't trained how to use them. There was no culture of safety. I could go on and on and on about the things that were not done. And as a result, they inhaled the toxins. So the cause of action was against the owners and the contractors. Now, oddly, the city went to Congress and said, help, we're going to, and this was September 2011, September, help, we're going to get sued, give us some funds. And I believe it was October, Congress, through FEMA, gave $1 billion to the city and the contractors. But horribly, in a one-sentence public health law pronouncement, it was ambiguous as to whether the money was to pay the claims or to defend against the claims. And the city and the contractors, for reasons that I talk about in the book, and I think that are outrageous, chose the interpretation that they're going to use the money to defend the claims, not pay the claims. And that's why they left, This was even the judge said there were this was just scorched earth tactics used. I mean, we would get dumps of a million pages of documents on a Friday at 6 o'clock just to ruin our weekends. They would fight us every step of the way. They brought a claim on immunity, which basically there was a series of archaic statutes based on the Korean conflict that have immunity for civil defense emergencies. Most states passed them in the 50s. They pulled that one out, dusted it off, and claimed that it guided our case. And if anybody's interested, I have this amazing transcript where we went to the Second Circuit Court of Appeals. Sonia Sotomayor, before her election to the Supreme Court, her court just vilified the defense on this argument. And I have the transcript if anybody can email me, and it's just fascinating read.
You know, hearing you talk about these issues around personal protective equipment, of course, I can't help but think about the debacle we had in this country dealing with COVID, with the lack of PPE in the hospitals and for nurses, and once again, for first responders. Do you think, I mean, litigation may arise out of this? Do you think it should arise out of it? Are there other ways that you would recommend dealing with this problem? Do you view that as a sort of evidence of failure of the litigation path in some sense, because here we are now with another debacle kind of overlapping with the same issues that arose for your clients in the 9/11 cases?
You know, as soon as COVID started happening, I started thinking about all the litigation that can happen against everybody for everything. And it didn't remotely excited me. It made me anxious and nauseous. You know, I have to say, and this is odd being a lifetime litigator, but as the dean introduced, I'm now in the world of mediation. I look at as litigation as a necessary evil, but I think it's an evil to the extent it creates such negativity. Certainly, we need opportunities for people who have disputes to resolve their disputes. There's just no question, and we have to have litigation forums. But litigation can be its own end and its own evil end. And it can be limitless, and it creates just not just a negativity, but it becomes a cottage industry. People are doing it for reasons other than for truth and justice. So we could talk a lot about the litigations that are going on right now, or could happen, or the immunities that have been granted by Congress. But that's a really complex area. But I'm not happy about litigation that arises from these circumstances. I want resolution of conflict whenever possible. It's just better. It's better for, you know, a healthy society.
For Professor Naomi Mann, very interesting talk. Thank you. What role do you see mass tort class actions playing in the access to justice function of the court system? What are the limits, and what other systems could achieve justice through the legal process? I know you just touched on that a little bit with your comments about mediation and such. Do you have further thoughts on that?
Yeah, I mean, listen, mass torts and class actions, you know, have great value. But you know, I don't know about you, but I regularly get a notice in the mail, and it's about another class action, and it was for something that an electronic device I bought 12 years ago, and I'm going to get 72 cents. I'm not sure that our society is winning by that. You know, certainly lawyers are winning by that. If in fact one of the benefits of those actions is making manufacturers keep higher standards, then I'm all for it. And in fact, that's one of the espoused benefits of the tort system, is not necessarily recompensing those that are injured, but it's a warning to those in society that, hey, we're going to hold you to a standard to make us the safest society on the planet. And I like that aspect. Sometimes there's not such a cause and effect between that, though, and sometimes there is. So this is, again, another very complicated issue.
From Professor Kate Silbaum, most of our students are familiar with the Station nightclub fire litigation. In that light, could you share how you gathered the lawyers who were representing one or two clients into the group, and what your own concerns were about identifying all appropriate defendants before the statute of limitations? And she adds, I mean, tort students here study that litigation in the Station nightclub fire.
Right. And the question is just how we grouped together as plaintiffs.
How
And
you gathered the lawyers who were representing one or two clients in the group, and what your own concerns were about identifying all appropriate defendants.
People often ask, me, why you? How did you get 10,000? There were about 10,500 total plaintiffs, and we had, my partners and I, we had 10,000 of them. What had happened is we got a first case, and it became a second case, and then the press reported and became a few more cases. Unbeknownst to us, there were lawyers in New York City that had filed notice of claim. So in New York, there's a condition precedent when you sue the city. Before you start a lawsuit, you have to file notice of claim. And there were, I think, over 100, 150 of those filed based upon ground zero. But those lawyers never brought those lawsuits into those notice of claims into a suit. And, and we did. And what I often have said is it was ignorance and arrogance. And the arrogance was, I just felt, my gosh, you've got healthy people, and they were exposed to dust, and they had cancer. So, I think I can win that case. But the ignorance is the utter complexity of it in suing 150 defendants, and then in going through 10 years. And I think that's why the other lawyers in Manhattan, my office was in White Plains then, didn't bring an action. They were, in some ways, they were a lot smarter than I was. They were aware of the enormous cost and the pitfalls. So what happened is it just grew and grew and grew. No one else took the case. So we ended up, other firms who represented unions, et cetera, reached out to us, said, we don't want anything to do with it. Let's partner up. And they referred cases to us, and we co-counseled. In terms of finding out who the defendants were, that's just public record. At the end of the day, it's every contractor that was at the scene. And, that's just a basic discovery, freedom of information, disclosures, and just, due diligence by us in determining every single one.
From Professor Robertson, the plaintiff's bar does not have as clear of a career path as compared to the defense bar. What advice do you have for law students looking ahead?
Yeah. Wow. Well, first of all, I will say, even though I said before that litigation is a necessary evil, litigation is a great opportunity for certain lawyers to be. It involves such creativity. And I never realized that I was a creative person until I sort of got into the obstacles of this case. But at the end of the day, it's almost unlimited. You're only limited by resources and by ethics, and how you accomplish your goals. So those that are creative people, that have a great interest in being tasked with enormous obstacles and being challenged, it's awesome. And whether it's a jury trial or a bench trial, it's a process, and it can be incredibly exciting. In terms of, and there's not much litigation out there for law students. There's personal injury, there's criminal litigation. Most of the heavy business litigation is bench trials, which is more discovery based and less what you think of when you see on TV jury trials. In terms of plaintiff versus defense, there's enormous opportunities on both sides. And it depends upon whether you're looking in the business side, the personal injury side, or the criminal side. To me, the best opportunities for law students are those doors that open up other doors. Those things that give them access to a lot of people, a lot of areas of law, a lot of other relationships, a lot of entities, so they can really understand. I think what's so unfair that we often do to college graduates and law graduates is requiring them, or they feel they need to know what they should be doing. And how unfortunate and unfair is that? That's an impossibility. Who we are and where we're going depends upon where we were and who we want to become, but it changes every day. or changed every year or changed every 5 years. I'm still working on evolving as a person and the different things that I want to do. So for lawyers to think, oh my gosh, I must do on the defense side because this will do this, is just so unfair to them, or the plaintiff side. I think law students should look at opportunities for the vastness of what they'll introduce them to next.
From Professor Zeiler, I'm curious about your views about immunity from liability granted to hospitals, nursing homes, et cetera, in relation to COVID.
Yeah, well, I mean, when I first heard about that, I was relieved, because the last thing I wanted to hear was, you look at these people who are on the front lines, and these nurses and doctors who are depressed or suicidal, and they're exposing themselves. And now for them to be culpable for missing that one thing during an emergency, I felt great relief. But there still has to be standards that we hold our medical profession to and our hospitals to. So maybe, and I'm just riffing out loud now, maybe we limit, if we were allow lawsuits, it's limited to gross negligence or intentional, acts that are just punitive, that should be punitive in nature. Boy, the last thing I'd want to do is hold people. And we do have a standard in tort law, and it's called the Emergency Doctrine, which is, when you're in an emergency, you're held to standards of people in an emergency and less so. And by the way, for Ground Zero, that's what the city argued. They said, this is an emergency. How could you expect us to get, respirators for 10 or 20 or 40,000 people right away? And we agreed with that. The problem with our case, in our case for the defendants, was it was a 9-month cleanup. And if we give them latitude for the first week or 2 or month, sure, that's an emergency. And then there should be a different standard that applies after that. But personally and practically, I have no problems with immunity to the people that are our heroes right now on the front lines in COVID.
Well, believe it or not, we're coming to the end. We've had a ton of really interested and engaging questions. Last one here is your thoughts on the role of the jury in the civil litigation system, its function in mass litigation in particular, and the jury more generally. What do you think about juries at this point of your career and their role in our system?
I like juries as guiding forces, but as being definitive in terms of particular events, it scares me a little bit. And the reason it scares me is that we all have so much bias and subjectivity that we come to the table with that affect our decisions and judgments. And those aren't open and obvious and apparent to trial lawyers. So you don't always get justice because of that. But I will say, what I do love about the jury system is that we take lay people for granted. Our ordinary citizens are much smarter than people give them credit for. They're living every day. They're experienced on the trials and tribulations of life, and they bring a freshness and an honesty to decisions they have to make. So while I'm concerned about their biases that we don't uncover, I really like and respect that they often reflect, core humanity.
Mr. Bill Groner, thank you so much for delivering this year's Shapiro lecture. It was a terrific talk and a terrific conversation afterwards. So thank you again for spending some time with us here today. It was, I think, a great experience for all of us.
Great. Thank you so much.
Virtual round of applause, I think. You can give them. Thank you so much.
Great. Thank you.